that it for you, counsel? Or?
No, Judge, I have one more. This is going to make my head explode.
Graham Partner versus Fry. Well, let me just call all four because I think we got an issue. Mika Fry, Naja Brown, Going Robinson, and Raisha. You all just come up because I mean I'm going to have a similar one. They can just line up down that side. All right, who do I have here? Your name.
Morning.
Robinson. So the one I'm missing is Fry.
4 tenants walked into court expecting another eviction hearing. Instead, the judge immediately realized something was seriously wrong. The property management company had changed, the lawsuits had been amended, and buried beneath the paperwork was a much larger legal battle, already unfolding in other courts. Within minutes, the judge admitted the situation was so confusing that even he wasn't sure who had the legal authority to move forward. What happens next leaves everyone in the courtroom waiting for answers. Welcome to the Judgment Room.
All right. So the last time we were here, we had a problem with these properties because these were filed. These are really Arbor One cases, right? And the part that I'm a bit confused about is, so for filed in the name of Beal, then there was some indication sent out that Ram Partners is now the management company.
That is what I understand as well, Judge. So we're going to have to file amended complaints.
Yes, but I don't know what I have amended complaint.
Oh, they've already filed them. Okay, I was told.
Well,
filed.
they filed them.
Yeah, I'm actually here for Ram Partners. No, because it was under
Who
Beagle.
are you?
I'm the property manager for the property.
Okay.
I just found out.
What's your name?
An hour ago, Jillian Bailey.
Okay. So here's going to be the problem in my mind, because I've got to sort this out. The last time we were here, the balances were of such a level, at least on 3 out of the 4, if I'm recalling, that they covered a significant time period. Typically, that might be okay, except that these are really Arbor One cases. Arbor One has there's significant litigation in our circuit court as well as the federal court. And so I don't know, first of all, whether this management company or whether Arbor One can proceed on these. And that may be part of the problem. The other issue in that is that since some of the amounts were of the nature that they were, even if on X date they could proceed, I'm worried that the back balances were part of something else. And it worried me even more because the new management company came in, so they're going to be looking at the number that they would have. I get that. But they may or may not know that part of that number may have been dealt with or disposed of to the extent that they can proceed. May have been dealt with in the circuit court. So I think my head just exploded. I think it just went just Friday.
Misery loves company, Judge.
All right. So that's where we are. I don't know what yours. Go ahead.
Judge, I was brought into this late yesterday afternoon. As you know, Ms. Holm has been handling this. She's on trial today. What I have when I discussed this with her, she said that she's having difficulty accessing the circuit court ROA to get the actual documents that she needs to know whether or not this court has stayed. And I suggested, and I have not had the time because I was on trial yesterday, whether we should talk with the prosecutor and see whether or not they can tell us where their cases are. And so that's my hope, is to sometime next week sit down with Ms. Holm when we're both in the office together, get a strategy together, and maybe contact the prosecuting attorney to find out where their cases are, to tell you whether or not you can go forward on these. Because she has tried, and I know she's been working on this, trying to access the ROA for the circuit court unsuccessfully, to access whatever order there is that tells you essentially, whether or not you have the right.
Right. Whether or not these cases can go forward. I will tell you, and just to back up, because I don't know that I told Ms. Holden. After the last hearing, or maybe the one before that, I can't remember. Because there was some confusion on my part, I contacted the other side of that litigation, that being legal services, to try and determine whether or not these folks were well, I was really more focused on the units, because there were some units that didn't have COC, some did, and I don't know when all of that transpired. You want to say something, because you always do. Go ahead, no.
Stating that it was a property management, that's been nice. I moved in, I was moved from the buildings that were not under compliance, and I was moved into a building that also was not under compliance when I moved in, and I have the email stating that when I withdrew my rent and everything. Also, I just want to mention.
Well, what time period are you talking about?
This was December 3rd of 2025, and I have the email from the property manager stating that they did not have even temporary certificates at that time. So.
In December of 2025.
Yes, and then I continued to email from there. I shouldn't
Go
say
ahead.
to email from that point on, I kind of got ignored, and then so reaching kind of before I came here to court, I made an agreement with Jessica Nice. She said I did not have to pay this balance to avoid the eviction process, and I do have emails and paperwork regarding that. So when I was supposed to leave, I was summoned to court.
Jessica with who?
Works with Bill Properties.
Okay. Anything you want to tell me?
It's got a eviction on my record, so I can't go anywhere. So when I do apply, so
You're trying to figure out what you can do if you want. I got you.
stressed out.
And
You're stressed out?
I'm 50 years old. I want to be on.
You're not 50. Don't even try.
I'm
All right. All right. All right. So first of all, quit stressing. Because you stress, then I stress, then things get bad.
Okay.
All right. Mr. Robinson, anything you want to tell me, sir?
I was told the same thing she was.
And
They gotta come back up. Now they want to pay.
okay. And so council, just so that, because you weren't part of those other cases, I had about before the case got filed against Harbor One et al., the federal part of that came in. I still had, up until sometime last month, initially starting 50 Harbor One cases. Those cases were working themselves through in some way, but then got stopped because of the circuit court matter. At some point, and again, I'm sort of unclear, the circuit court was not preventing this court from going forward on those cases. I was just reluctant because there were global agreements going. What these two are telling me makes sense. Okay, because there were buildings where the certificate of compliance was not there. And I can't tell you off the top of my head which buildings those were at this point. I mean, I could look back at my records. But that rent, at some point, the circuit court ruled, because we had to get rid of escrow that was in our accounts. And at some point, that escrow was given back to the tenants, either in full or at a 50% rate, because they couldn't theoretically charge rent. But the money could have been used for the repairs. And I think Judge Kunke did something along those lines regarding that. We got rid of, ultimately, all cases where there was escrow and got those resolved. Additionally, with that, the cases that were here brought in the name of Arbor One were all dismissed. And so I was, when I found out, because they were filed in the name of Beal, and now they're filed in the name of Ram. Once I found out that it was Arbor One, I think it was Mr. Robinson that told me, he just blurted it out, and I stopped immediately because I didn't know that they could proceed. Okay. And also, council, I don't know what date, it was a Tuesday, I think, in April. Council, was it Bodman that was representing? They were representing Arbor One. And on the day that we got rid of the last of the cases that were before me, part of that large group, they made no mention, which I think they would have, that there were more Arbor One cases coming.
I could confirm that with Bodman's attorney.
Okay, because I think that may be, certainly you can go to the prosecutor about where things are, but you may want to also go to them as to whether or not, because it may be, and Ram may or may not know that, it may be that they can't at this point proceed on these cases. But if you can, I mean, I don't mind hearing them, but because I like banging my head against the wall. But I don't mind hearing them, but it's just, I just want to make sure everybody's operating in the right way. And and I just want to make this clear. I don't doubt what those two are saying. I think, unbeknownst to a lot of people, these balances on some of these things got wiped. And not everybody knows, because that's what was happening on a number of different cases and units. All right, so what do you want me to do? Because I'm going to go back and rest for a minute.
Well, before you do that, Judge, perhaps we should adjourn.
Yes. And how much time?
I've got to coordinate with at least 2 other offices, Judge.
You guys are all still in your units, right? Okay. Why don't you think if I kick them out to the 29th, just do the last Friday in the month and then figure out where we are? Does that work?
That should work, Judge.
All right. Then I'll adjourn these to May 29th, 2026, 3 p.m. in person. Okay?
Thank you, Judge.
You, young lady, you told me the last time you were on Zoom that you were all stressed out. You were giving me a bunch of stuff. All right, now listen, just listen to me. All of this is confusing. I get it. It's confusing in some respects to me because there are all these moving pieces. Told me about some of the issues you had. Do not stress out about this, okay? You're not going anywhere. Nothing is going to happen until I say it's going to happen, and I haven't said so. So I do not want you worrying about anything. You hear me? You promise me? I don't care if you worry, because none of you worry, okay? You guys have a great weekend.
What makes this hearing remarkable is that nobody actually received a ruling. No eviction was granted, no tenant was removed, no final decision was made. Instead, the judge hit pause. And sometimes that's the most important decision a court can make. Throughout this hearing, one concern kept surfacing over and over again: uncertainty. The court wasn't convinced that everyone involved was working from the same set of facts. There were questions about property ownership, questions about management companies, questions about previous litigation, questions about rent balances that may have already been affected by other court proceedings. And when courts start encountering that many unanswered questions, rushing to judgment can create bigger problems than the ones they're trying to solve. The judge openly acknowledged how complicated the situation had become. In fact, he repeatedly expressed concern that tenants, property managers, and even attorneys might not fully understand how previous rulings could affect these cases. Rather than forcing a decision, the court chose to slow everything down and demand clarity first. For the tenants, that means additional time. For the property managers, that means proving they have the legal authority and accurate records necessary to proceed. And for everyone involved, it means returning to court with answers instead of assumptions. Perhaps the most memorable moment came at the very end. One tenant appeared overwhelmed by the process, worried about losing her home and frustrated by the confusion. The judge's response was simple. Don't panic. Don't assume the worst. Nothing is happening until the court says it is happening. For now, the cases remain unresolved. The next hearing could determine whether these evictions move forward, or whether an even larger legal problem is waiting to be uncovered. What do you think? Did the judge make the right decision by stopping the cases until the facts are sorted out? Let us know in the comments.
Thanks for watching, and don't forget to subscribe for more courtroom cases.